So I start with a question for Mr. Schlegelmilch. And the question is, ISDS is good for Europe because?
Thank you. Well, ISDS is good for Europe because we are the biggest investor in the world, outward investor. But I think the question is slightly misleading. If you allow me, I will nuance it a little bit into ISDS can be good for Europe, but we're not necessarily talking about what has been discussed in the past, because our main message, and that's the message I would like also to repeat here, ISDS needs to be reformed. I think it's a misinterpretation to say we just want to continue business as usual on this issue. And I don't. And one thing, for example, which is sometimes not mentioned in the debate, all these cases that you are worried about are happening on the basis of existing law. It's nothing to do with TTIP. These cases, Vattenfall was mentioned, the Australia tobacco case, Lone Pine, and so on in Canada. These cases are happening on the basis of existing law. There are 3,000 treaties out there which have ISDS. You might have discovered ISDS last year, but it's been around for 50 years. And we are regulators in the Commission. We're not just pushing the interest of one particular part of the community. We are the biggest environmental regulator in the world, to put it mildly. I mean, at least that's what our US friends tell us. And we have an interest to protect our regulation. ISDS is there. It's good if it's done correctly, and we'll talk about the reforms that we are looking at. But I would want to really clearly go on record that what is out there and has been the basis for some of these claims is not the sort of ISDS that we are negotiating.
So what do you want to reform? What could be done better?
Well, I think there are a number of things that can be done better. If you talk about arbitration, you get what you have on the books. That means the rules. The rules on investment protection need to be clearer. And then that's point one. Second point is you get the sort of transparency which is on the rules. We've always been arguing that the existing arbitration ways is not transparent enough, and we're arguing for full transparency on pleadings, on amicus curiae, and so on. And lastly, there's the money aspect. I think you also have to make the proceedings more accountable. Loser pays principles, things like that, will be very important in the future. So we're all for reform, and I'm happy to explain more, but I think I shouldn't dominate the debate too much in the beginning. But these are the important points. The rules have been drawn up 50, 20, 30 years ago with a very clear focus on what is that we want from other countries, not so much what do other countries or other people or investors from other countries want from us. And now we are seeing that these cases, which are actually taken on the basis of existing law, cause some problems for us as a regulator as well.
So why do you criticize the Commission so much, Ms. Eberhardt?
You mean why I criticize the reform agenda?
Yeah.
Because to a large extent it's not true. When you compare what the Commission claims it has negotiated with Canada, which will be a template for TTIP, with the actual leaked text, and relatively recently leaked text, so some of it is from February this year, the rest from November, you can see that the reforms, as they have been sold to the Parliament, to the public, to journalists, are just not in the text. And I would argue that the text that we have seen from the Canada negotiations would allow exactly all those scandalous claims. Lone Pine against Canada, Vattenfall against Germany, and many other claims that we will probably talk about in the discussion. These claims would be possible under the reformed treaty that the Commission has been negotiating with Canada.
So what happened in Canada?
What happened in Canada? Well, first I'd just like to say thanks very much for organizing this event. Normally when there's a Canadian on the same table as someone from the Commission, they're trying to sell them tar sands or trying to lobby against the Fuel Quality Directive, and so I promise I'm not going to be doing that. Seals, don't get me started about seals. So the experience in Canada, I mean, first of all, the Council of Canadians and many organizations, Labour, there's a very strong degree of unanimity almost in Canada on civil society that ISDS is just inherently anti-democratic. I mean, there's no way, I don't think, to reform this process in a way that would make it acceptable. The idea that you have three corporate lobbyists essentially deciding the legitimacy or not of a certain public policy, right? These are things that we expect in our democracy and in our basic understanding of what governments do to be the purview of democratically elected governments. I wouldn't trust the tribunals if it was, you know, Jesus Christ, Muhammad, and Buddha deciding if a policy is legitimate or not. But in fact, it's corporate lawyer 1, 2, and 3, and it's inherently anti-democratic, I would say. But just to get to the question about Canada, I mean, the experience is, I would argue very strongly, it's just been unambiguously atrocious. Canadian firms have not won a case against the United States under this process, and yet Canadian policies have been challenged more times than Mexican policies have, right? So this was initially in NAFTA thought of as a way to make sure that the courts, companies would have protection from the court system, you know, not being as fair perhaps in Mexico as it was in Canada. But in fact, the result has been Canadian policies, environmental measures have been challenged over and over again, with several payouts, controversial payouts. The Lone Pine case is ongoing, but this is of course a case against a precautionary moratorium on hydraulic fracturing in Quebec, which the company has declared capricious, arbitrary, and with no cognizable public purpose. And I, again, it's amazing, and the cases keep going on. I would argue just one more thing. I don't think Canada has any intention in the CETA negotiations of trying to make the process better, of reforming it in a way that would be positive. I think quite on purpose they've gone the other way, and this is actually a much more expansive investment treaty than Canada's ever signed.
Is Europe and Canada comparable to Europe and the US trade agreement, or is it very much different? Mr. Schlegelmilch.
Can you repeat the question? Sorry.
Yeah. Is it comparable to say the Europe and Canada agreement and the European and US agreement, or is it totally different from your perspective?
Well, first of all, CETA is still ongoing, as what one of our friends in the audience have reminded us, and that includes some of the issues that we are discussing today. Contrary to what you think, not every text that is leaked is actually the final text. Second of all, we haven't really made up our mind what we're going to do with the US, and that's why we have a public consultation. So I think, of course, what we negotiated recently and what we are negotiating is pretty close, I would think, to what we will actually do in the future. But of course, it always takes two to tango. I mean, we don't know what the Americans will come up with. And we will not fix our position before we have the public consultation. Otherwise, what's the point of the public consultation?
How is the debate within the European Commission, within the DG Environment?
Could you precise the question? There is a debate, certainly,
yes.
And there is a normal process we have normally in the Commission. And honestly speaking, I have not seen such a transparency previously on many of the negotiations. So there is an understanding on the side of the negotiators that for a deal where we have little to gain on removal of tariffs, because we have almost 0%, there is a lot of discussion to be done on non-tariff barriers where we talk about regulation. Then you need to involve much more the departments that have the policy in their hands, meaning consumer protection, health, employment, environment, climate change, energy, and so on. So just to reassure you, there is a debate, there is a proper due process going from the technical work. Today, there are negotiations also ongoing with colleagues involved. There is also a debate at political level, because you need actually the control, the oversight by the politicians to make some sort of progress. So to respond in a nutshell, there is a discussion, there is a due process, and we are also looking forward to the public consultation, what it will bring. And I think it was a very wise decision to go on the public consultation on something that seemed to be an ancillary issue probably a year ago, but has become an important irritant to a number of representatives from the civil society.
Why didn't the Commission started the public consultation earlier?
That's not a question for me.
For you as a citizen?
I think we had a debate in the Commission between the departments when the mandate was adopted, and I think we have voiced some question marks on the ISDS. And that is why the wording that has been proposed for the mandate has been so, I would say, reworked to put in all the possible safeguards that should yield additional rules and actually lead to the reform my colleague has alluded to.
What I hear is always, or one opinion is that American firms are lobbying heavily, that ISDS will be within the trade contract. Is this true? Can you say this is right or wrong, or what is your opinion?
Great, thanks. I'm going to answer that question. I also just want to take one step back. I think we went into the details really quickly and just make sure we're all on the same page here on what we're talking about. So if you just allow me 1 minute to say, the investment chapters of free trade agreements and the rules in bilateral investment treaties do a couple of things. And one is to offer broad, expansive, new rights to foreign investors and foreign corporations. So the right to a minimum standard of treatment and the right to fair and equitable treatment are two of the very standard and very broad, ill-defined, vague rights that are offered to foreign corporations and foreign investors. And then when a foreign corporation or when a foreign investor feels that their rights have been violated by a new law or a policy, say a commitment to phase out nuclear energy or a new policy to put a timeout or a ban on fracking, that foreign investor or corporation has the right to bring an investor-state dispute settlement case against the government, which is essentially suing the government in a private trade tribunal for essentially unlimited cash compensation. And to put that in the context of, for example, the climate crisis, which is where I come from this debate, we're at the point where climate impacts are occurring and climate emissions are occurring faster than we ever anticipated. Climate scientists agree that we need to keep 2/3 of global fossil fuel reserves in the ground. We have to stop exploiting fossil fuels. And to do that, we need to rein in the power of the fossil fuel industry, to stop exploiting natural, coal, oil, and gas, keep fossil fuels in the ground, and actually transition to a clean energy economy. That takes massive community, public, and government intervention. So we see investor-state dispute settlement and these massive rights offered to corporations is just a fundamental tension to what we need to do to solve the climate crisis. And to answer your question about who is pushing for these policies, it is unsurprisingly the very investors and corporations that stand to benefit most from the rules. So for example, Chevron, which is already involved in a number of investor-state dispute settlement cases against Ecuador, for example, has submitted its comments to the U.S. Trade Representative and is focused, it's 2 pages of comments, we can send them to you, they're available on the web. That's all about it's solely about establishing a world-class, I forget their terminology, but a world-class investment chapter, investor-state dispute settlement system so that Chevron can continue their business model around exploiting natural resources. So there's strong push from industry. And yet what we see is there's no reason for this. There's no barrier already to Chevron investing in the European Union or a European fossil fuel corporation investing in the United States.
Are there any questions from the audience so far?
Hi, I'm Cecile from Teeny. I just want to go back to something that Rupert said, which was that this newly revised ISDS or the anticipation for this newly revised ISDS would provide greater transparency on the whole sort of court case system. And I was wondering if you could sort of, for me I find that really difficult because you're promising to make something transparent out of something which is completely opaque. We can't see the legislative text that you're proposing on how you plan to reform this. So out of the darkness will come the light. I just kind of want to understand that process a little bit better. And then another was a comment, since the 1950s there have been ISDSs and, but that's always been on sort of state-to-state basis, but this is a relatively new EU competence since Lisbon, and I wanted to understand how, ISDS is really beneficial for the countries that take the high risks. But Europe isn't a country, and you have, the likes of Germany who might go off and take those high risks, but you have a lot of other countries who will be sort of receivers of those high risks. And I wanted to know how in Europe you marry that, and if you could maybe talk about the process of the policy to decide who will pay the bills. I know this is ongoing, but if you could give us an update, within the member states, how that, I can't remember, it's a regulation on... It's a regulation. Yeah, how that will be paid for. So sorry, that was 3 questions.
Yeah, true, but good questions.
Okay. Thanks. I mean, the question of transparency you have to settle in the agreement. You have to basically say an investor who goes to ISDS and a defending state will have to make public all their submissions or their amicus curiae. The pleadings will be public, so you can listen in when they actually make their plaidoyers for the case. This is something, as I've said before, which is missing so far, and that is, I think, will give a lot more legitimacy to the process, because people will know what is being argued rather than having to find out ex post what is being argued. And organizations like many of those who are here will be able to submit their own views to the panel, which I think is something we've been fighting for a long time in the various trade negotiations. I think that's an important point. And I also would like to come back, because this is also linked to, I've been more or less been told that I was lying to the audience here, because the Lone Pine would have happened anyway. I think I would take issue with that. First of all, the case in Canada is not transparent. You don't even know what the defense is, what's going on in that case. Second of all, it's a shell company case where a Canadian company is using a Delaware subsidiary without business, which we would not allow. We would only allow investors to sue which have substantial business in the country of source, which that case couldn't take place under our rules. And thirdly, it's a case about a legislation, environmental legislation banning fracking, which would stand in our view, because we will make sure that environmental legislation, and that is already in the League Canada text, environmental legislation will stand unless it's manifestly disproportionate or something like this. It has to be really completely out of the ballpark to be able to be attackable. Nobody would argue that a ban on fracking, given the uncertainties about the effect of fracking, is manifestly disproportionate. I think that's just not going to stand. So I really take issue with the fact that such a case could happen under our reformed rules. Now, then there was a question of the risks and the member states. First of all, it really is not new. Almost all member states, I think Ireland is the one which doesn't have a lot of treaties. Almost all the member states have these treaties. There are 1,400 for the 28 member states, and they all have investor-to-state dispute settlement. The problem is there. Not doing anything is not the issue. Vattenfall and other cases are coming on the basis of existing law. I have to repeat this again and again. Not doing anything on this issue will just mean we have more cases, because if you look at the number of cases, they are growing. But they also have not attacked, and this is in response to the climate change point, we have a pretty tough emissions trading system. We have a lot of environmental regulation on climate change. Nobody has attacked that so far, despite the fact that it is attackable with the treaties if you really want to go after it, which are out there on ISDS of the member state treaties. Now, to your question, this is now an EU competence, which means slowly but surely we will take over in the way that when we do an agreement, for example, with the United States, the 9 existing BITs between the US and individual member states will be folded into this bigger agreement. So it's actually an opportunity to get rid of some of the very broad and, as some have said, unqualified, I'm not sure it's massive rights, but there are some treaty provisions which are not very well defined in the existing treaties, and actually we can do better than that. It's not massive rights, if you ask me, because under our own constitutional laws, and this is back to the question, do we need it at all, which I'm quite happy to talk about, under our own constitutions, we protect property. I mean, it's not just that only ISDS treaties protect you against expropriation. If you go to a court in Belgium or in the UK, if you're expropriated, you have a right to be compensated. That's fundamental law. And that is what is reproduced in these international treaties. So I think we have to take that also, I think, a little bit with a grain of salt. if we would be arguing, or if any of you can argue that we are giving more substantive protection to foreign companies via these treaties than we give in our own constitutional systems, I mean, we would be dead. Come on, we cannot have better protection of property for foreigners than for nationals. That's not what we're talking about. It is less, in most cases less, because you have a number of principles in the treaties out there, I've just said, which are quite limited.
Yes.
If you look at German private protection property rights, you won't find the principle of, compensation for regulatory taking, for indirect expropriation. So that is a perfect example of a substantive right that is broader, very standard in international investment treaties than in German private property protection law, which is, as you rightly say, pretty strong. I don't know what this means now for your announcement that we would be dead, but it is one example of a standard that goes further, and maybe that is important to understand before we only keep talking about the investor-state dispute settlement process. For us, the system really has two problems, and the first problem is that it grants investors rights that they do not have in all constitutions around the world. They go much further, and the example of, compensation for regulatory takings, for indirect expropriation is just one of them. And the second problem is this highly flawed process, this parallel legal system that investors can use to claim these rights, to push them through. And this system is really only accessible to them. But I also wanted to, if I may, react to three other points.
Maybe I give a chance to react.
Just on this point, this is for German lawyers. The Germans invented this idea of an enteignungsgleicher Eingriff, which is an expropriation, which is not a real expropriation, but if you cut off the electricity of a company, you're actually doing expropriation. The Germans invented this thing.
Well, I can say that I read from German lawyers that German law does not know this concept of compensation for regulatory taking. I also wanted to react to the point that you said the problem is there, we have to address it. The problem with shitty investment treaties that exist today is very easy. You can tackle that problem easily. You can terminate these treaties. If you don't like them, if you've made a mistake, they can be terminated, all of them. And many of them could be terminated today. The problem is that they have this crazy clause, which we call the zombie clause, that will mean that even if you terminate it, investors will be protected for 15 or 20 years on the basis of a terminated treaty, but still you can terminate them. So there's absolutely no reason to say we have a problem with the existing treaties, therefore we need to negotiate a treaty that is much more far-reaching and dangerous than what has ever been there. On the Lone Pine case, would it have been possible? You're right, that was a mistake from my side. The EU, the latest EU text from the EU-Canada negotiations would make it impossible, or at least very difficult, for a letterbox company to sue. What I was having in mind was more the substantive standards that Lone Pine and also Vattenfall refer to in their claims. And that is, for example, the standard of fair and equitable treatment, the hardcore of international investment laws. When investors win a case, they win it very often because this standard has been violated. And maybe to just back up my accusation of lies, here the Commission said you said in your briefing from November that you have strictly defined this clause, and that is simply not the case, because when you look into the leaked text, you will find a definition, but after the definition, you find a clause that basically says, and by the way, FET will also mean everything else. So this is why I said you are lying, and this is why I would say that Lone Pine's arguments, which center, for example, around this standard, would still be possible under the existing treaty.
Okay. There is a question very in the last row. Yes.
Is there a microphone here?
No.
Good argument why this is not needed. You said in European countries there are the same rights. Well, there is discussion whether that's true or not. But if you believe that there are the same rights in German law or in French law or in Dutch law, then this is not needed. companies can go to court already in Germany or in France, and that's happening as well. So I think apart from arguing that the improvements are not valid, are not true, are sometimes the way you communicate about it, I will call it misleading, otherwise maybe the debate gets a bit too offensive. But there's a lot of examples. You say about transparency. The transparency in the CETA case is limited, because confidential business information can be an argument not to give transparency. We have a bit of experience of how the Commission itself deals with confidential business information. We often ask access to documents requests, and then we get half pages crossed out, blackened, because that is confidential business information. We don't believe that if you say transparency, but these are the exclusions, that this will bring the crucial information. It's always the crucial information which is blacked out. But I think I would like to ask you, why do we need this system in the first place? Because there is not a single good argument. An MEP asked the Commission, are there good reasons in CETA, in Canada, good cases that would illustrate that companies could not go to court? The Commission could not come up with more than 2 examples. Legal experts looked at these both examples, and they both found out that either the company could ask compensation or the company could go to a court in Canada. So you didn't have any good example, any good argument. So, and I think you're not understanding as a Commission that the problems with ISDS are not so much whether the improvements are good or not, but there is a fundamental problem, and Stuart has been saying that. It's 3 lawyers with conflicts of interest which don't have to be bound by case law, which don't have an appeal mechanism, and all of these problems are not solved in your improvement. So that's the argument why we don't need the system at all.
And do you have just one concrete question? There was one in the middle.
The question is, why do we need this?
Okay. And the answer is?
China.
Well, I'm the first to admit that this is a much more difficult question in a way to answer, because I'm not going to stand up and say the justice system in the US doesn't function, or in Canada. That would be stupid. Huh? It does function in most of the cases. But even with a country like Canada or Japan or the US, you might have problems for 2 reasons. First of all, politics in the world are the same everywhere. We won a case against the US on an expropriation of a trademark which was Cuban-based. We won a case at the WTO. The Americans did not implement. The trademark was taken away because Cuba politics is irrational. I mean, you can don't quote me in public on this, but that's the truth. I mean, even at a US court, you might have problems getting a case of that kind through. There are a number of other cases in the US where juries on the state level have taken some strange decisions. The legal point is different. The legal point is the following. There is no anti-discrimination obligation for the US. They can do whatever they want. They do, for example, in procurement, they have Buy America, you have no access, you have no standing, and the state is sovereign, you cannot sue the state in the US. The only way you can sue the state in the US if you have a major problem is through international treaties like a TTIP. Because the rights that you're getting in the treaty are not invocable in the domestic court. The lawyers will know what I'm talking about. It's an extreme point. It might happen, not very often, but I think it's, after we've seen on some of the cases, it's still not a bad idea. You might not be convinced because it will be the exception. And the second argument, somebody already said China. I think the fact of the matter is, if we think, as the Commission thinks, being a big investor and having cases, in the recent case like Argentina, Repsol expropriation and so on, that such a system is needed, despite the fact that it might not be as needed with the developed countries and the others, then you cannot drink wine and preach water. You cannot tell the Chinese or the Argentinians, we would like to have such a system, very well defined, very narrow, but protect the core of the property, and then tell them, but you don't need it for the rest of the world because you're a second-class legal system. So there's a political argument that we will have to be mindful of if we pick and choose. I mean, I wouldn't say we cannot do it. Politically, of course we can do it, but I think it would be very difficult to have the system only with parts of the world, and also telling the American or the Canadian investor, the Chinese investor might sue, or the Indian investor, under these rules because we have a BIT with a developing country, but you cannot. So there are these systemic, if I call it that, issues which you have to think through or which you have to take into account. But again, I mean, the case is a lot stronger, and I'm the first to admit that. The case is a lot stronger with certain jurisdictions than with others. We would not deny that.
Just to respond to 2 points there. I mean, first, we fundamentally oppose investor-state dispute settlement, on any level, and the idea that you'd be elevating corporations to the level of nation-states in and of itself is objectionable from our perspective. And again, noting that, the U.S. Constitution already protects investments, including from foreign investors. And on the political point, I would just note, for example, that the United States has free trade agreement, for example, with Australia that does not include an investor-state dispute settlement system. Australia had refused to subject itself once again to investor-state dispute settlement cases. Australia is still formally asking for an exception in the Trans-Pacific Partnership Agreement post the egregious cases that have been mentioned by Philip Morris suing Australia over its public health and anti-smoking regulations. So I think the idea that it's impossible to leave ISDS out of one agreement and then not be able to include it, in another, I think is misleading. But again, we reject the process on a more philosophical level, practical level.
I'd just like to maybe respond briefly to there's one case in Canada, I know it's being used by the Commission as an example of why ISDS would be needed with Canada. It's the case of VG Gallo, which didn't go to the end. It didn't end up in a settlement. It was dismissed because the tribunal found that, in fact, this person wasn't an investor under NAFTA because they were an American citizen who had basically purchased the company for, I think, $1 or even for free at some point, and so it was dismissed. But the case itself, I would argue, would have naturally gone ahead to a tribunal otherwise. It was a mine that was going to be built, or proposed to be built in Northern Ontario. Not a mine, excuse me, a landfill. The company called this decommissioned open pit ore mine, a flooded ore mine actually, they called it, quote, the ideal site for a landfill, end quote. It was going to accept 20 million tons of waste over its lifespan. This was going to contaminate the region for about 1,000 years, according to studies. It was massively opposed by First Nations in the community and farmers working together. This was in the 90s, been going on for a long time. By 2004, a new government decided we're going to end this once and for all. They put in place legislation that would make it impossible for any company to ever put a landfill in this sensitive, ecologically sensitive area. And the company sued for $355 million under NAFTA. That was the claim. They were claiming that they didn't have access to the courts, that in fact the compensation wasn't there, that this was an expropriation without compensation. As the Canadian government put in its defense of the case, in fact, the law that actually expropriated or made it impossible for the landfill to go ahead actually gave the company what would have been higher than market value. The formula that was used to decide compensation would have given the company more than they actually deserved on the market value basis. And in fact, they did have access to the courts. This was another argument. They did, along the whole time, have access to the courts. When they filed their NAFTA challenge, they had just simply decided not to take their legal case to that next step. They went to the NAFTA case. So, I mean, it's not a very strong argument, I would say, to suggest why we need something like this with Canada. I also just want to, if I can, comment on the Lone Pine case, which has been suggested that would never happen under CETA. The lawyer who's representing Lone Pine in this case has been quoted in the news saying, this is the perfect example, he said, of why we need these investment protections in treaties. This is the case, right, that shows why we need the treaties. And to give you a sense of who this person is, he's actually on contract, or has been over the past 5 years in the CETA negotiations. He's been on contract by the Canadian government to help fulfill the Canadian government's position on investment in the CETA negotiations. So here we have someone who clearly expects this kind of case to be used again and again to challenge European policies.
Magda, and then I saw another hand.
I have a couple of questions, if I may. First, you, Mr. Stegelmisch, you said that you would protect the legislation, and especially environmental legislation, by having a clause that would not allow looking at it would have to be really extravagant environmental legislation that would be subject to the case. But who would decide if the case is admissible or not? This would be the free lawyers in the corporate lawyers in the mechanism itself. So I see that as why wouldn't they decide what is extravagance? How would they decide what is extravagance or not, comparing to what we would consider extravagant or not? And the second question I wanted to ask to Ilana, because yesterday Dan Mullane said that basically the US has already a golden template, ISDS, that was developed in 2009. I assume that they would want to have that kind of ISDS in the agreement, so maybe you can tell us a bit more how it works or it doesn't work in this situation.
Okay.
Yes, I think on that question, again, I think we share some of the concerns that the choice of arbitrators has been a bit maybe deficient in the past. I mean, the clear view of the Commission is that if you allow such a system, it has to be basically functioning like a normal court. You have to have a clear idea that these people have no conflict of interest. You cannot be an arbitrator and at the one hand advise clients, on the other hand arbitrate cases. We have to introduce this, and we are having a code of conduct which will be rolled out on that. And we also have to make sure that there is a certain stability in the system. We are actually suggesting that we need an appellate body. You have now a sort of annulment procedure already for some cases when you're not happy with the award. But it's clear that that hasn't been good enough in the past, and that there has been conflict of interest. We don't dispute that either. The way to deal with that is that you have to have some idea who'll be on the roster, that you have their CVs and their interest, they have to declare their interest, and that you have to make sure that you cannot appoint someone who should not be there. I mean, this is as simple as that. Otherwise, it's not defendable, because I take very serious the criticism if you have a parallel system to the domestic court, you know, it has to be as credible as a domestic court ultimately. The other issue is if you have this sort of setup and you have problems with the arbitrators, the relation between domestic court proceeding and ISDS. I think it cannot be, and again, this is something where we will be very strict, it cannot be that you just do pick and choose, you try your luck under in the investor-to-state dispute settlement, and if that doesn't work, you try your luck in the domestic court. There will be very strict rules, and there are very strict rules which we develop, that you have to choose. You cannot do both. You cannot ask for compensation in two parallel fora and then have, of course, try the better one. That is also important. If the investor wants to go to ISDS and to this, has this choice, he cannot go back to a domestic court and then try to have a better ruling under maybe a different law system. I think those are issues which are very much on our mind. Again, I need to say again, we are regulators at the Commission. We do pass a lot of environmental regulation. Colleagues here are just as concerned as you are in many instances. We don't want to be ever our hand bound by three arbitrators who do whatever they like.
Thanks for the question on the U.S. It's known as the U.S. Model Bilateral Investment Treaty, and so it's exactly true that we know really exactly what the U.S. has been proposing in their starting proposal for the TTIP investment chapter and recent free trade agreements. So the U.S. government, led by the State Department, actually went through a process of consultation to come up with this new model bilateral investment treaty. The Sierra Club and a number of our allies, along with obviously a huge number of business representatives, industry representatives, actually did participate in that process. I would say that the views of the environmental, labor, consumer rights organizations in that process were pretty categorically dismissed. So the real fundamentals of the U.S. proposal absolutely remained intact. So some of the elements of that, also to talk about, we already talked about fair and equitable treatment, minimum standard of treatment. I'll say a little bit about how that's changed since the sort of revisions to the U.S. proposal. But I'll actually even just start with the definition of investment. which goes far beyond like actual real property or investments. It includes, you know, futures, derivatives, expectation of risk or profit, natural resource concessions, and permits are actually listed as part of an exhaustive list of potential investments. We tried to significantly narrow that definition. It has remained intact. There were some sort of preambular language that was added, but that doesn't have real sort of legal standing. The definition of minimum standard of treatment, for example, was clarified a little bit in an annex, but we've now seen the result of cases that have come from the Central American Free Trade Agreement since 2005, where we've seen that any changes that were supposed to clarify the definition of minimum standard of treatment have not been effective, that cases have still gone forward, and that awards have still been awarded to investors. So fundamentally, the model of the US has stayed intact. It still keeps all the fundamentals of investor state and the real definitional problems that extends from the definitions of investment to all the broad rights offered to corporations.
Yes.
I just wanted to come back to the credibility of the legal system. I mean, I guess most of you know in this room that the investment arbitration system, if you compare that to key principles of the rule of law, I mean, you cannot take any of them. And let me just highlight two really basic flaws of the existing system, how it works today. And I would say one basic problem is it is not a fair system in the sense that one side can only play defense, states can only defend claims, and the system provides no equitable access to justice. So it's only the foreign investor that can use the system, not a domestic company, and also not a community that might be affected by bad investment of an investor. And I think these principles, I don't know how what your relationship to the rule of law is, but equitable access to justice and judicial independence, I think, are really key to the credibility of legal systems. And I would argue that these basic flaws are not at all addressed by the current reform agenda of the European Commission. Equitable access to justice, it's not possible. Amicus, imagine an investor then suing a state, and then a community might also bring in their views via a separate brief. That is not equitable access to justice. It's a highly discriminatory system, discriminating in favor of one group in society, which is foreign investors, and against anyone else. And your reform proposals, I'm sorry, but they don't change anything of this basic flaw. And I think it is a key question. Why should we do that in a democracy? Why should we give one group in society so much more power than any others? And coming to the question of judicial independence, please don't think of these tribunals having anything to do with courts. These are for-profit arbitrators deciding the cases. They have no fixed salary. They earn more the more cases they are. And that is an inherent incentive to keep the system investor-friendly, because only the investor can sue. That is a striking conflict of interest. And again, that will not, we have seen previous proposals of the Commission's Code of Conduct. I didn't see that basic flaw of the system addressed there. So I think it's not going to be addressed. And for the points you say that you are already doing, which is a code of conduct preventing these conflicts of interest, there already is a code of conduct out there in the world from the International Bar Association. It hasn't changed anything with this basic lack of judicial independence. And the roster. We also have a roster already today. When investors sue states under ICSID, and then the investor appoints one arbitrator and the state appoints an arbitrator, and they cannot agree on the third person, then there is the ICSID roster, and the third person comes from there. And so this is exactly what you're proposing. We're already having it. It doesn't have it doesn't lead to any more judicial independence in the system. So please don't be confused. This is a highly flawed system, and the tinkering around the edges, a bit more transparency, maybe an appeals process in 10 years' time, maybe a code of arbitrators after we have signed the agreement, are not really tackling the basic flaws, and we should really be outraged. And I don't know if there's lawyers in here. I'm still hoping still waiting for the big resistance movement of lawyers who hold dear to their constitutions and think we care about something like judicial independence, we care about something like equitable access to justice, and we oppose investor-state dispute settlements in all EU agreements.
Well, I honestly hope that the public consultation will surprise you maybe for the future on which rules could be adopted or proposed, and that you will also contribute to that. But I wanted to react to certain points that were mentioned in the debate. Actually, it is, I mean, it's a very valid question on what is manifestly excessive when we have two societies which have a little bit slightly different concept of societies on certain issues. We have seen from our side, we have become an irritant many times in the discussions, be it on seals, when we discuss with Canada, and with the US. The classical example in the past was REACH, the chemicals regulation, because if you look, the difference we have with the US is huge. They have a legislation that dates from 1976. This is the year I was born. We have REACH. So here the difference is actually huge, and it will be very difficult to see what the manifestly excessive measure might be. So I think we will need to look into the doctrine and avoid any sort of exceptions that could be there. I actually was also struck by some statistics to see that 12 arbitrators were deciding 60% of cases overall in the world. That's really striking, and I think for the future there needs to be really clear rules on avoidance of conflicts of interest, etc. And I'm confident that our colleagues in the Commission are working this way. I must, however, react to a point you made about the termination of bilateral investment treaties. It sounded very simplistic. And I must tell you, following the discussions from the competence we got from the treaty, Lisbon Treaty, on the investments, and then discussing it with member states, it proved absolutely difficult to move the EU competence into the investment treaties. So I would really caution against statements saying, oh, you can just end it like that, the bilateral investment treaties. No. And there are many member states, you clearly mentioned some of them, who have less administrative capacity or are weaker in judicial terms, who have no interest in doing that. We are a little bit on the receiving ends of certain cases, be it in Romania or in Bulgaria, with big investments. So I see there that there is really a lack of capacity, but there's no willingness to terminate any sort of bilateral investments. So I would really like you to not to go out with the message that's peanuts. To the contrary, it is good that EU is moving a little bit in the territory and it can throw its weight behind a treaty. On the solidity of judicial systems, it very much depends in Europe. We have had now the second report by the Commission on the length of procedures in different member states. And it's quite interesting to see the differences. You have member states with very robust judicial systems where the commercial or civil proceedings go relatively fast. You have a number of member states, in particular Greece, Italy, or Spain, where the proceedings are extremely slow. So I would like also to a word of caution on the, let's say, general impression about the solidity of judicial systems as absolutely only alternative in this case. And I can only agree with you on the access to justice. That's indeed a problem, in general a problem, not only for the enterprises, but also for the NGOs. And we are now looking into the possibility of opening up the access to justice on environmental matters, for instance, in the EU. We have tried so since 2003, but we have been so far very, very unsuccessful, mainly due to the resistance of member states.
Just to respond to the question also on subsidiaries, I would just note that there are many, many examples where subsidiaries are used to bring investor-state dispute settlement cases. So in the example you gave, potentially a Chinese company can use a subsidiary in the United States to sue the European Union. The case that we've been talking about quite a lot tonight, the Lone Pine case, just to remind us again, is actually a Canadian company with an office in Delaware that is suing Canada, but all of its operations in mining and extraction for oil and gas are in Canada. And this idea of substantial business is just, again, an extremely ill-defined subjective term that hasn't prevented the use of subsidiaries to bring cases.
If I could just make one comment, and that's that I feel like the conversation's kind of straying towards there are reforms happening and they're going to be positive, when I think we started well kind of laying out that in fact the reforms that have been proposed in the CETA are completely insufficient. In the Canadian case, and Canada's bilateral investment treaties are normally very similar to the US model. This is more, I guess, a step towards some of the European bits than it is towards the more cautious US approach on definitions of fair and equitable treatment. So we're not talking, I think, here about honest reforms that are going to make this system better. There's even, and we've touched on this a little bit in terms of the most favored nation clause in the CETA investment treaty. There's been 2 studies done, analyses of the leaked text. They're both available on eusecretdeals.info, which suggests that it would essentially undo any of the positive reforms to the definitions of FET or expropriation, because companies will be able to rely on definitions that exist in previous treaties that the European Union has signed or previous treaties that Canada has signed. And on this point, I want to stress again that the Canadian government gave us this line throughout the past 4 years that of course we're going to reform the ISDS process and we want to avoid frivolous cases, and they used Lone Pine as an example of a frivolous case. But we recently in Canada, I shouldn't say we, the government has recently in Canada signed a treaty with China. And it's very clear that they built the MFN into this treaty in such a way that Canadian companies would be able to use definitions that exist in Canadian treaties that happened between NAFTA, between certain period of time, essentially prior to Canada had made these reforms that the United States has also made to the definitions to improve them. So Canada is very objectively and very specifically building these things, these kind of loopholes into these treaties to give its companies maximum room to file challenges in other countries. And I think that's happened in the CETA as well, based on what we've seen of these analyses. I'll say one more thing, and that's why would Canada do this? The Canadian mining industry, mining is one of the most important industries in terms of influence. It's kind of like oil and gas in Canada. Has very recently, in the past 2 years, started to come out with statements supporting every treaty that Canada signs. Every year they have an association meeting, a mining association meeting in Toronto. And every year for the past 2 or 3 years, the government has gone to this conference and announced that we have 2 more investment treaties, for example, with Tanzania or Nigeria. And then there's a statement of support from the mining sector. And I think these things go together, this kind of purposely expanding these definitions, making it more likely that a tribunal will, one, take up a case that's been brought by a Canadian mining company against, for example, maybe Romania, in the case of the Roger Montana gold mine, or as we've seen Canadian companies doing increasingly in Latin America against gold mines they can't get developed in Costa Rica because there's a ban on gold mining in Costa Rica, for God's sakes. So I think this is very clear policy agenda of our government right now is treaties, mining, and who cares what the communities say? We've got the treaty to protect the companies if anything goes wrong, if the community says no.
I have a question for Ms. Eberhardt before I come back to the public. We already have hundreds of ISDS in place, and Germany might be the market leader, maybe the inventor. And I'm wondering, so far I didn't feel that there's a danger for me as a citizen. I didn't feel it, as I mentioned before. I just know that there is ISDS maybe since half a year or a year. Why might TTIP make the big change, the big difference?
First of all, this is very common that countries sign these treaties, no one knows, parliamentarians sign them off without really understanding. Then you have the first claims, like in the case of Germany, 2 Vattenfall claims. And that very often changes the debate. It happened also, for example, in South Africa, which was forced or signed many of the investment treaties in the 90s. Then there was a very scandalous case of Italian Luxembourg investors challenging the Black Empowerment Act in South Africa. And that's when South Africa realized, whoa, wait a minute, that was not what we had in mind. What did we do? And South Africa is now learning its lessons. And if I just may come back, I respond to the question, but to the question of terminating treaties. I'm not saying it's easy. And I also know, maybe that's important to raise here, that the EU member states in many of these issues have an even more horrible position than the European Commission. So I'm not wanting to give the illusions, that EU member states could just easily terminate the treaties. But it is possible, and it's exactly what South Africa is doing at the moment. Getting a lot of pressure from the EU for it, and from EU member states, but it is doing it because it is drawing the lessons. So what would be different with, so that's just to explain why does no one know or so few people know and why is it suddenly becoming an issue. And I think it's important to say these existing treaties are enormously dangerous, and many of the people in the room here have opposed them for many years. Still, there's a good reason to be even more afraid of TTIP. For several reasons. First of all, look at the massive transatlantic investment flows. We're really talking trillions. Investment that is already there, and that investment would be covered by the treaty. There are tens of thousands of companies, and Public Citizen did an excellent research on that have subsidiaries on both sides of the Atlantic. It's really a crazy corporate network. All these tens of thousands of companies could file an investor-state dispute on both sides of the Atlantic just whenever they dislike legislation. So the size of it is really enormous. It's incredibly dangerous, I would say an unprecedented threat to taxpayers, but also to regulatory space on both sides of the Atlantic. And maybe to add one last extra risk, the legal industry. If you look at who actually benefits a lot from all these claims that are filed around the world, then it's again and again the same law firms. And most of them are based in the US, and they are very actively slapping out client alerts or briefing papers to their multinational clients, informing about changes in mining legislation here, a new health law here, patent protection laws in another country, motivating their clients to sue. So if you put investor-state dispute settlement in an EU-US trade deal, you will be confronted with a very litigious industry that will find its way through your very weak reforms and sue EU countries like crazy.
Other questions?
So, I had one that wasn't replied in my first round of question, which was dealing with the EU regulation and where the status of that was. Yeah. And then another one that wasn't replied, which was about the ISDS consultation. But I just wanted to go back to something which you picked up. You said the word risk at one stage, and if as a citizen, if I undertake a risk, I take out insurance. If I drive my car, that's a risky thing. I take out an insurance. If these businesses want to undertake the risky business of investing somewhere, could we not, as a society, just expect them to take out insurance? I don't expect society to pay for me when I, run over somebody without my insurance. As a citizen, that's what I do. And I just, if a company takes on a risky business, get insurance. Don't expect society to pick up your bills.
Clear question, and the answer is?
Actually, you can insure your country risk, and I mean that's clear. Yes, but I think that is not exactly the same thing as trying to get what you think you're entitled to. I think even the insurance will ask you if there is a BIT, maybe to make a claim. That's actually what the insurance company, if I were an insurance company, would say, if there's a treaty which protects you. So that happens, and some people know about these things. This happens. One more word on the other questions that came back. The public consultation, well, as we sit here, we are trying to finalize this text, this public consultation. It's a complicated issue. It will come out as soon as I possibly can. I had hoped it would come out on Friday, tomorrow, but it will have a little delay. And the other question was on the regulation. The regulation is hopefully still doable in this European parliamentary cycle. The regulation will basically have the basic principle that those who are responsible for the measure have to pay. So if you're implementing faithfully in EU regulation, then the EU will have to pay because it's the regulation that is at the basis. If you make a gross mistake and you do something which is not covered by EU law, then you're, as a member state, you're responsible. That is the very basic principle. And there might be mixes of both, so we're still trying to sort out rather difficult legal questions. How do you defend yourself in such cases? But it will come. It will just be, but it's an internal issue, I think, to a point. As any budgetary responsibility has to be actually put where the act that actually led to the responsibility is situated. There is one point that I would like to, if I have the floor, if you allow me to say one word on this question of the US claim, the danger of US claims. I'm not so convinced that we will have a massive number of new cases for two reasons. First of all, there are already 9 member states which have, for 20 years, they have treaties with the US. Altogether, there have been 9 cases, if I count correctly, in 20 years. So that is not exactly a huge number. In the same vein, I think the law firms and the possibility to sue via the subsidiaries and so on, they are there. And I would be the first to argue or to agree that there is an industry out there who's looking for work. That's clear. I mean, American lawyers are there to clock on hours and to make cases. That is true. The point is we have to discourage that, for example, by changing some of the rules. It cannot be that there is no loser pays principle, which most BITs don't have. I mean, if you take a case and you lose it, you pay. That will make companies think twice before they go into arbitration. If you think only half of your cost will be paid because the rest is the defendant has to pay no matter what the result, that is an incentive to go suing. There is also this point of frivolous claims. We have to be able, for shell company claims, which we have seen are one of the problems, that these cases are thrown out immediately. So except embarrassment, nothing will come from them. Those are the things that we have to do. I mean, we're not going to get rid of the US legal industry by whatever means. And as I said, they are already doing this. The Vattenfall case, these cases are basically run by US-trained lawyers who have all the means via the number of treaties which are out there to do this sort of thing.
I have one follow-up. Do you have any idea about the German position? Because since I mentioned they invented it and its history of German investment that you have ISDS in contracts, and now the government is a bit more defense, I might say, and not in favor anymore. And I'm wondering, is this because for the first time they could be the one who are sued on, or what's the reason?
I mean, it's difficult for me to speak for the German position. I mean, what I can tell you is that we have a mandate, but all 28 member states agreed to our negotiating mandate, which included investor-to-state dispute settlement, under a proviso, which I think is well known, that will only do it if the result is right, if it's balanced, if it's in our interest. So I think that's where they officially stand, as far as I'm aware.
I can just respond to one point really quickly. On the point that there are 9 bilateral investment treaties that exist between the US and the European Union, Public Citizen, Melinda's in the room, and her team recently crunched some numbers on this. You can correct me if I'm wrong, but right now there are about 50,000 US firms with investments in all of Europe. And if you look at just the bilateral investment treaties and the investments in the 9 countries where we have investments, that covers about 7.5% of the investment. So by expanding TTIP to the rest of Europe, you're including the other, 45,000 such companies that will now have access to use investor-state dispute settlement against the European Union. So there's a massive increase in liability. Indeed.
Magda, and then the last row.
So it's me again. It's really fascinating. I wish I was a lawyer because I think I better agree on that. But I have 2 questions. I'm afraid again to Mr. Fracking. The Commission says very clearly that there is a big effort to support SMEs, and also within the TTIP that there will be a focus on small and medium enterprises. I somehow fail to see how the small and medium enterprises would benefit from TTIP, which from ISDS, which is a system that you need to have some means to hire the lawyers. You need to be big. You need to be registered on both sides of the Atlantic, or at least on the, because it's not for domestic companies to sue. It's for the foreign companies. So I see a big disadvantage for the SMEs that actually the Commission wants to support. And how do you resolve that? And the second question is, if I understand correctly, the TTIP would actually overrule the existing bilaterals that the member states are in with the US. Is that correct?
No.
So if the TTIP is without ISDS, wouldn't it overrule the existing BTAs? And if not, why not? I'm not a lawyer, so I'm asking maybe naive questions.
Yeah, Mr. Schlegelmilch.
Thank you. On the first question, it's not absolutely correct that it's only big companies who use investor-to-state dispute settlement. About 20% of the cases are smaller or even individual companies. You have wealthy investors who feel that they are getting a bad deal. There are calculations, I think I take them from the NGO community, that cases or UNCTAD used to be $1 million, now it's apparently going up a lot to $8 million, but even for a wealthy individual, people take that risk. So I have a number, 20%. I'm not sure whether some of you have done some research, but it's not just the big companies who do this. Of course, they have deeper pockets, that's clear. On the other question on how it will work, well, if TTIP comes into force and if it has investor-to-state dispute settlement, the member states' treaties will be phased out. They will disappear at that moment. That is the principle. Contrary, if you're talking about the other situation, if there is no investment protection rules, then the BITs will continue to be there. So only if we have that in, then there will be a phase out. These treaties will be sort of discontinued. You have to terminate them, but there are rules in there which allow to do that.
Then it's possible to terminate them.
Well, all these treaties can be. I mean, this is very clear. All these treaties, and I think it has been said from the panel here, these treaties can be terminated, and then you have the sunset clause, you can, whatever you call it. You have a clause which, of course, the investments which are there, they have another lifespan of which protection which ends only 10, 15, depending on what you have years later.
But, sorry, so how did we get in the first place to a situation that only with ISDS we can have that deal? That's what you are saying more or less now.
Is there an answer?
No, there's another comment and question.
Okay.
So, it's in there because the negotiating mandate. We're negotiating on 25 issues. It's a political decision to have these 25 or whatever issues. We could have also included more. We could have included less. And we have a policy from the Commission in general, which you can read in our communication on investment or on the free trade agreements, to have a comprehensive approach, which happens to include this particular issue. But there are other issues in there where you can say, well, do we have to have that in an FTA? Maybe yes, maybe not. I mean, there is intellectual property protection, which is sometimes contentious, rights on that. There are rights on sanitary and phytosanitary deals, which is a WTO plus, if I can call it that technically. So it's a political decision. The breadth and the broad of the negotiation is a political call that is done. The Commission proposes something, the Council agrees, the Parliament makes a comment, and then off we go for a negotiation.
So this condition is a Commission proposal? This thing about it only overtakes bits if it's got ISDS in it, and otherwise it doesn't overtake them. That's a Commission proposal.
Two things. The phase out is a part of the EU law. That is in the regulation which we've done earlier. The question of so phasing out, you cannot have two sets of rules. You cannot have member state treaties and the EU treaty having an EU-wide agreement.
Yeah, I mean, the bits only phase out if the new treaty includes ISDS.
Yes.
That's a Commission proposal.
Well, if any treaty, if the EU in any forum agrees to have an EU-wide agreement on investment protection and investor-to-state dispute settlement, then the member state treaties will disappear. That is part of a regulation we passed a couple of years ago. So it depends whether an agreement has ISDS or not. I mean, we have FTAs with Korea, for example, which were before Lisbon, There is no investor-to-state dispute, no investment protection, no investment-to-state dispute settlement. So member states happily go on having treaties with Korea. I hope that's clear, but...
plenty of other questions. Maybe we get all the questions. I see 4 hands. And then 5. And then we answer them in one row. And we have more than just one on stage. So just start questioning now.
I have a comment and actually some questions to Ilana, Stuart and Pia. The comment is based on a PR paper by the EU on the CETA agreement, where in its first sentence it reaffirms the right to regulate. And we just put up a website called EU-secretdeals.info, where we put some arguments and analysis of these kind of claims and of leaked texts online. And the analysis by the International Institute for Sustainable Development on this EU claim, where in fact they reaffirm the parties' right to regulate in a manner consistent with the agreement, is what they are proposing in CETA. The legal analysis there is very clear. Quote IISD, the legal analysis is extremely clear and simple. It does nothing to establish or enhance a right to regulate. Rather, it does the exact opposite. It makes it clear that the right to regulate is fully subject to the agreement. So this is just one example of the EU Commission's PR work and the reality of what they are doing in treaties. So my question now is to Ilana and Pia and Stuart. The Commission is now preparing a consultation. What's our strategic approach to this? They want to limit it to the ISDS and TTIP, because Mr. Schlegelmilch and his colleagues have to admit that they will lose this battle and have to get rid of ISDS and TTIP anyway, but they don't want to talk about CETA. They don't want to talk about the energy chapter. They don't want to talk about the liberalization of services and other issues. There's no systemic reason for this, but they don't want to talk about this in public and with European citizens or US citizens or Canadian citizens. So what is our approach to this consultation? Thank you.
I think we are talking about everything right now, but anyway, the next questions.
Chair, thank you. Mark Johnston, I work in Brussels with the European Policy Centre. One comment and then one question, both to Rupert. The comment, Rupert, you said twice at different times that, quote, the European Commission is the biggest environmental regulator in the world. I think that's not a correct statement, because it's the Union, not the Commission, that is a regulator. So Parliament, Council and the Court, as well as the Commission, working together on, and that changes the democratic equation, obviously. The question is, in 2 weeks' time, Obama will be here in the building across the street. TTIP and climate change, amongst other things, are both on the agenda. I'm new to trade, so everything I hear about it still shocks me about how bad it seems at first glance. Let's see how it plays out. But let's assume for a moment you're open to this deal between Europe and America. We are open to this deal between Europe and America. Where's the leverage and where's the trade-off between those two issues, between TTIP and climate change, when the head of the US delegation is sitting here in 2 weeks' time? I don't see anything. It's kind of full steam ahead with TTIP, and climate can sit on a back burner. Climate policy is stuck in Washington. We know that. Climate policy is slowing down in Brussels, which kind of matches Washington, let's say. The President of the Commission, at least sometimes, the President of our Commission here at least sometimes says that climate change is the most existential challenge we all face. And yet, in terms of a political agenda for a conversation between Europe and America, it falls off the agenda. So why has the leverage, if I can be more precise in the question, why has that potential leverage between facilitating fossil fuel trade and, on the other hand, as we heard from the Sierra Club, keeping most of it in the ground, where is that leverage in our political conversation with America got lost? Thank you.
Thank you. The third question just left. The fourth is here. Yeah.
Sorry. Question to Mr. Rupert. Sorry, I wanted him to say your second name. It also has to do with policy coherence, not the rhetoric and policies of the European Union about economic sustainable development. What would be the implication of the so-called anti-localization measures within the ISDS system? We have heard pushes for anti-localization measures both by the European Union and the United States, but you didn't mention it now when you were talking about the specific clauses that the investor state would contain. And the second question is, if I understand well, you're saying that the European Union and the US are willing to continue imposing the investor state system upon the world. Is this like an MAI reloaded? And in this sense, will the European Union pursue an investor state system in the next EU-Mercosur negotiations? Thank you.
And there was a final one, yeah.
Thanks, I think it's very helpful in the European Environmental Bureau. So I had one question, one clarification to the point you just made about if there was a bit with Korea, for example, and that would still stand. But if you had most favoured nation and you had an EU-US TTIP agreement with ISDS, then presumably a Korean company could say, we want to go for that, and we therefore want to use ISDS, so it could, by default, apply to every single trade agreement that's agreed in the European Union. So it'd be helpful to have clarification on that. And then on the point about corporate lawyers and lawyers about, I take issue with that slightly. Yes, I am a lawyer, but an environmental lawyer, and that leads to my second question, which is, what about having an arbitrator panel which had public interest lawyers, environmental lawyers, health lawyers, in order to give a perspective of what the laws were and why they were important, rather than just leaving it to corporate or trade lawyers? I mean, what would you do to ensure that actually the people coming in were actual lawyers or judges or came from that background?
Thank you. So, Pia, the first question was for you as well. Are you going to be transparent and make your strategic approach transparent for the next couple of months?
Yes, we will participate. We will encourage others to participate, but we will also work on other issues. And we actually agreed that Stuart is starting the response on that question. But I wanted to, just on the idea of putting other private lawyers with other kind of legal expertise in these tribunals, it would still be for-profit lawyers. It would still be people who earn more the more cases are there. It's really not the way to go for a judicially independent legal system, but there are alternative proposals out there in the world that go much more into the direction of equitable access to justice and judicial independence. And this is for an international investment court of judges with fixed salaries, but a court that would be accessible to all. So not just to the foreign investor, but also, for example, to the many communities around the world that are fighting companies like Chevron, who are just massively destroying the environment they're living in. So I think it's really not, we shouldn't get into the trap of reforming the private arbitration system, private arbitrators deciding these cases. That is really the wrong way to think about it, without idealizing the courts we have on the national level. No, you wanted to just have the questions first, no?
Yes. So. That was the approach.
Well, I'm going to try and answer this question on the approach. So humble suggestions, perhaps. So the CETA negotiations are obviously very close to being concluded, but we've seen from the leaked drafts that investment chapter, they still have some problems or some differences of approach. I would suggest potentially you could freeze the CETA negotiations, as has happened partially with the TTIP on the investment at least. Freeze them immediately. I would include CETA, the draft we've seen, and in the consultation process, I think be transparent and say this is what we've done so far. As I said earlier, the Canadian and US model bits are essentially identical. So presumably the compromise you will come up with in TTIP is going to be very similar to the compromise you've arrived at in CETA. And assume the possibility that the answer at the end of the day is no ISDS, right? And if that's going to be the case of no ISDS in TTIP, it should be no ISDS universally, whether it's Singapore or Canada, and have that as an option. And I say that, I'm kind of pleading with you in a way because, the Canadian government, we're quite masochistic about these things. They have psychological problems, and we're facing $2.5 billion worth of NAFTA claims right now. We've got challenges against a decision to build a new bridge across into the United States so we can actually trade more with the United States. The one guy who owns the existing bridge says this is going to expropriate his potential earnings. We've got cases challenging our patent system. Eli Lilly saying that, you know, a decision by the courts to actually revoke a patent in 2 cases was illegal, was against the NAFTA and the WTO. So here they are trying to enforce WTO rules through investor-state dispute settlement. So it's clearly not just about property. I mean, they are using these things to enforce other agreements. You know, there's cases. Well, we could go on. I won't, but we could go on. It's gotten to a ridiculous point. Canada's not going to do any consultation on this in any time soon. So we would really like it if you could please do one on CETA as well.
And now we come to climate change and Obama. This might be a question for DG Environment or the Cabinet.
Not really. Actually, CO2 left the cabinet a few years ago, but I can probably say a few points. There are 2 sides.
I think you can still identify with
certainly,
that.
Certainly. I worked on climate change before when I was in the Secretary General, so no problem with that. Actually, there are 2 sides of the coin. It's what do we want to achieve on climate change through the TTIP. I think what we always try to do is to promote some sort of positive agenda on green goods, etc. But indeed, there are also differences in how we take the climate change issue. So the only thing I would see is actually the issue of shale gas. That is indeed very much Europe seeing with a lot of appetite probable imports of gas, excesses of gas from the US to Europe to lower the gas prices and maybe to avoid the damage that can be done here in Europe on fracking and with different geological formations we do have. But we really need to define quite clearly what we want to do on, I mean, what's the interest of phrasing the question of climate change at all, because I have had the impression that so far it has been only reduced to the fossil fuels and to the prospect of lower gas prices here in Europe. So I can't say much more than that, but on the other side, I know that there has been certain pieces of legislation that has been pinpointed by the US as problematic, like the Fuel Quality Directive that has been mentioned already before. Indeed, this is something where we cannot prevent the Americans of raising the questions, because it's, again, like the seals or tar sands for the Canadians. It's an irritant for them. We see it on the endocrine disruptors, for instance, on chemicals in another area. But there are also areas where we want the American legislation to be taken over and implemented in Europe. For instance, car emissions, for car standards for NOx are much more stricter than we do, or what we do have here in Europe. So I would like also to dispel certain feelings that there is only, the bad environmental regulation on the other side of the Atlantic, and we have all the best here in Europe.
Thanks.
Great. So I'll start broad again and then get a little bit more specific. But I would just say, again, the right to regulate and the imperative to tackle the climate crisis is at fundamental odds with investor-state dispute settlement that we're talking about today, but much more broad than that, about the entire model of corporate-driven free trade. So broader, again, than investor-state dispute settlement, just to say a few words about another major issue in the United States and now in the European Union about shale gas. Right now, because of the extreme exploitation of the US natural gas resources due to fracking, the United States is in a position to be an exporter of natural gas for the first time ever. And normally, in US law that dates back to 1938 in our Energy Policy Act, the United States Department of Energy has to, at least before approving any exports of natural gas, do an analysis, a simple, what's called a public interest determination, to at least examine the economic and environmental impacts associated with exporting natural gas before approving any exports. That requirement for a public interest analysis is eliminated for any country with which the United States has a free trade agreement. And in those countries, so as a result of TTIP, potentially, well, not if TTIP comes to be, as a result, the United States would be legally required to automatically approve all exports of U.S. natural gas to the European Union without even being able to do a simple analysis. And that has huge implications both for, again, exploitation of natural resources in the United States, puts a tremendous amount of pressure to frack more, to destroy our landscape, to harm the health of communities and our environment, but also has really serious implications for our global climate. We don't believe at all that natural gas is a bridge fuel to anything, even for domestic purposes. But by the time you extract it, you send it to the natural gas export terminals, you liquefy it and cool it, you transport it, you regasify it, and then you distribute it again. In the European Union, many analyses show that life cycle emissions is actually more damaging or as damaging as coal. But again, and the European Union has proposed a chapter in TTIP that's on energy exports. And what it clearly, the objective is to remove any export restrictions on energy sources. And in the United States, there's only export restrictions on two sources of energy, and that's crude oil and natural gas. So again, you have this fundamental clash between the IPCC and climate scientists saying 2/3 of fossil fuels must stay in the ground, must not be used or consumed, and then a trade model that removes the ability of governments to even examine, much less try to control, the flow of energy and fossil fuel trade.
There was the next question on anti-localization measures.
Yes, I mean, if you allow, I'll reply to all the questions that have come my way. I'll try to be very brief, but I want to also do justice to some of the comments. There was this comment on the right to regulate and being consistent with this agreement, which is an interesting legal construction, and I'm the first to agree that it's probably not worth very much. Huh?
Why is it the first issue then in your PR paper?
No.
Don't you think it's annoying?
No, because
for citizens?
I don't think it's annoying, because I think it's something which hasn't been there before. But I think it's perfectly okay to say it's not worth very much, and I'll tell you why. First of all, you have to be very careful. If you put into a treaty a clause saying I have the right to regulate, for a lawyer this means that the right to regulate is constitutionally created in this treaty, yeah? Which is stupid. Of course we have a right to regulate. That's why I, with my little knowledge of the law, think something like this is stupid. Of course we have a right to regulate. We don't have to write it in treaties. We have to make sure that what we do in the treaties don't curtail that right. But I'm the first to say, if somebody thinks it's a good idea, we can say we can put it in the treaty, but it will make our life more difficult in those treaties where it doesn't appear, because then people will say, but that is not in the other treaty. So,
Mr. Schlegelmilch, how dare you?
No, it's a fact. That's what even local courts.
The public with these kind of papers, if you are now making this statement.
No, I don't think I'm fooling anyone. I think we've been asked to put it in. I put it in. I'm here telling you that from a legal perspective, it doesn't make much sense. From a policy point of sense, it might be a very good thing to do to show people that we respect it. But it will not win you a case. That is important. It will not win you a case. Yeah? To be very clear.
It says consistent with this agreement and blah blah blah. So.
Which is an NAFTA language, by the way, which is something our friends from the other side of the Atlantic have. So I mean, what? But let's have a frank discussion. I'm not trying to defend the undefendable. Huh? Very very clear. But it's an improvement because people have asked us to put it in to say something about the regulate, and I will defend also that it's better than nothing.
So may I call this a lie?
No, I don't think. I think you should say you put it in perspective, what it's worth. It's not going to solve all your problems, and that's all I'm saying. Yeah?
But the United States can't regulate its natural gas exports.
Well, I'll come to that in a second. But I mean, we have to. I'm the first to say we have put this in because it's an improvement, but it's not going to solve the problem that there is a tension between the right to regulate and there is no. And by the way, I also be very clear: there is no unlimited right to regulate in none of our countries. The state cannot do whatever it wants. There are limits to the right to regulate. You cannot just expropriate people. Sorry. So you have to look at this a little bit more carefully. And the right to regulate we all have. I mean, if we're going to come say we don't have it, the whole point is where does it stop? Where is the right to regulate curtailed more than in domestic law, if that's the case, and that we would reject in these treaties than what you naturally have in your constitutions? I think that's a fair assessment of what we try to deal with. But for political reasons, we have had this call to put this in, and we will put it in future agreements as a reassurance for all those. But legally, I mean, frankly, it's not going to save the day if it says consistent with this agreement. I mean, that is clear. We never said anything else. I mean, quite frankly, even our text no, but our text doesn't say that will solve all the problems. It doesn't say that. Sorry, I mean, I really think we need to be fair to each other on this particular point. The second point was about the political economy of climate change and trade. I think my colleague has already said a number of things. It's not that we think there are trade-offs to be done. I think this agreement is in the interest of the EU and US because it will hopefully do something to revive our economies and get rid of some barriers which are just cost and not benefit. And this is why we're doing this. We're doing it, and we are doing it because of that, not to grant extra right to anyone. But we thought even the tariffs which are still there are quite significant. And most economists at least agree that tariffs are a nuisance. They will not add something positive to your economy except something for the money purse. And there are regulatory barriers. I mean, not everything is as contentious as some of the environmental things, which are just making money for certification authorities, for bodies who've been there forever and have to test everything and so on. That's not really needed, and it's not going to give you more consumer protection and other things. Nobody will argue, this is the classic example, that an American car is less safe than a European car. I don't think anybody would really want to argue that, despite we have double costs for these certification business. But it's not, though, that we will say we will only give TTIP to the US if they do something for us for climate change. This agreement has to stand the test of being worth it on its own. And that's the debate we're having. Is it worth it? And all the elements, are they worth it? We're having a robust debate on that, and I welcome that. Maybe some parts will not be worth it. I don't know. But it's not linked to the climate change agenda that we can trade off these things. First of all, that will not work. Second of all, it will just complicate things even further. And I don't think that's the mindset of either side to link all these things as a sort of political deal. Then there was the question of the delocalization. I have to ask the question, you mean the prohibition of localization requirements, which is being discussed in many trade agreements, saying you cannot be forced to locate your production in my country before I allow you to establish this sort of thing, or to bring certain parts, performance requirements, as we call it in our technical language?
Well, yeah, that's what I mean, but not with that language. It's the promotion of local development through, helping investment in one country benefit certain regions. I mean, put it in a positive way.
Yeah. Okay. Well, on this point, the policy that we have is that we don't think it's a very good idea to force people to localize, be it any part of their supply chain in a specific part of the world. That is because we think it's just a way to protect your own industry. It's a development angle in the end. For development purposes, it might be different. If you can show that you need this industry to develop in your country, and that's for the reason why you have to bring, for example, in China is doing this all the time. If you want to invest in China, you have to bring certain patents, certain technology, and so on. We basically think that's not a very good policy. The market should decide that. But we have a very, very robust debate with development interests who say, no, look at what Europe did 50 years ago. They had all these policies. So in the US, it's not an issue. I mean, neither the US...
It is an issue, the Buy America initiatives.
Okay, in that respect, I have a very clear answer. This is pure protectionism. The Buy America is something which is 50 years old. It's basically something which favors American steel if you want to build a bridge or mass transit. We call this protectionism. Very, very clear, and we're trying to get rid of it. But of course, many in the US see it differently. It's very clear. And of course, but if we all do this, there would be a lot less trade, and I'm not sure that's what we defend as a EU. We're not. By the way, we're not imposing ISDS on anyone. We are negotiating. We don't have it in Mercosur. Somebody asked the question on Mercosur. It's not part of the Mercosur mandate, which dates before Lisbon. But we have, to be very clear, we have the policy to have comprehensive free trade agreements, including investment protection and ISDS, as of 2010 after Lisbon. We have a communication which is on the web which says that. For the time being, that's the state of the policy.
Thank you.
I think I have to stop. Yeah, no.
Yeah.
Oh.
Okay, yeah. Fair enough. The final.
Yes. This. Thanks for asking this question as well. This is an important, really important question, because my point is the problem is already there. We have all these treaties. And we have to improve the system, and that of course means you cannot have MFN clauses which import through the best treatment available in any other treaty into your treaty. So our policy is to say there cannot be.
How did it get in there?
Let me finish. I mean, this is the policy which we are developing, because this is a problem that we didn't think about for a long time as well. That if depending on how you interpret these clauses, you might import even into the Canada agreement, and we're still grappling with the issue. You might import the 1,300 other EU treaties or the Canada treaties, the NAFTA and so on. As a policy, I can tell you that we are working on a solution which will not allow this, because otherwise the reform, this is what we are doing, will not work, because as long as there are these treaties out there, you will just use the entry point and claw back whatever provision is in other treaties. It's very complicated to read these clauses and to know what they mean, whether they really import these standards or not, but the risk is there.
Thank you very much.
Could it also happen the other way around? So my question was, if you have TTIP and you have a free trade agreement with Korea, could a Korean company say, actually, we want... So is this actually a way of potentially, even though it's an EU-US trade talk, becoming global, because companies all over the world start using
Yes or no?
I'm not sure I understand the question, because there's no investment in Korea. No, but I mean, what I hope is that we will actually set a good example which will influence the other treaties, even if we don't legally change them. There will be panels will see that the rule of the law 2014 is that, and it's different than what they have.
Yeah, thank you. I want to thank all the panelists, especially from the European Commission, because it's often said that they are not transparent, that they don't want to debate, that they hide under tables, and I don't see someone under the table. They were all here, and
hide the texts. They are here. They talk. They hide the texts.
They hide the text. Yes, they might hide the text, but I don't think if ever was there a... Well, if you bargain, it's very difficult to put everything on the table. I think that's the main problem, and that's the key problem.
Regulations can be discussed. This isn't about tariffs.
Okay.
They say themselves.
Yeah, a lot of room to debate, and I say thank you very much, and I think Magda will say a few last final words.
On behalf of the organizers, we would like to thank all of you who joined us this afternoon. As we can see, these were really exciting debates, and I also especially would like to thank our guests from the Commission, because you were slightly grilled here, I realized. So I also hope that you will come and see us again for similar events. I would like to thank all the panelists who were at this session, and also those from the session earlier on the food and TTIP. The negotiations are still going on, so we are going to look into what's happening on Friday, what news the Commission can reveal at that point, and we are definitely going to follow up the TTIP issue. And seems like we are forced to also follow up the CETA issue. So to our Canadian friends, we will be definitely in touch. Thank you all for joining us, staying until almost 6 o'clock. And big thank to our moderator as well of the whole afternoon.